We are discussing Section 7 of the Endangered Species Act, and we have come to the landmark U.S. Supreme Court case on the Endangered Species Act, TVA versus Hill, decided in 1978, and this has to do with the no jeopardy rule of the ESA, and it has to do with the snail darter. Okay, so this is a very famous case. There's a book that environmental law professor who was involved in litigating with a bunch of University of Tennessee law students against the Tennessee Valley Authority on this very subject. They worked with a farmer named Hill, and the professor's now at Boston College, but he wrote a story, he wrote the book about kind of the story. And basically the whole idea was that the Tennessee Valley Authority was going to build the Tellico Dam. It was going to create a lake for a bunch of development and flood control and so on and so forth. And it was going to flood a bunch of farms. So there were farmers who were unhappy with it. But lo and behold, scientists discovered that it was also going to destroy the habitat, the only known habitat at the time of the endangered snail darter. Okay, so that's what the snail darter looks like, a little tiny thing. And so so there's a lawsuit under the Endangered Species Act contending that the dam violated Section 7, which prohibits federal actions that would jeopardize the continued existence of the species. So that's that's actually what eventually was built, Tellico Village. Anybody been there? Okay. So that was what was built. There's the boating on the reservoir of the lake. There's the back of the dam, front of it, larger area of the dam, homes on the reservoir, etc. So the U.S. Supreme Court, so it goes all the way to the U.S. Supreme Court, and the U.S. Supreme Court engages in statutory construction. And by the way, the Tennessee Valley Authority, right, they're the agency that is making the decision to build the dam. And are they entitled any Chevron deference? And the answer is no, because the Supreme Court says that Congress has spoken in the plainest of words, making it abundantly clear that the balance has been struck in favor of affording endangered species the highest of priorities, thereby adopting a policy which is described as institutionalized caution. Okay? And so so basically the Supreme Court says that the statute is clear, and they actually use the word absolute in terms of the protection this afforded the species and the prohibition on any federal action, no matter how important, that would jeopardize the continued existence of the species, including destruction of its critical habitat. And one of the things they said is, if Congress means something different, they can always amend the statute, the ESA, and provide for that. So along comes the action in Congress, and they create what's known as the God Squad. Okay, so so they create a God Squad. And this is a group of mostly cabinet-level officers that can decide that the project is so important that it is entitled to an exemption from the Endangered Species Act, even though it would jeopardize the continued existence of the species. So this is created, and then this is all the way back when Jimmy Carter was president. So they formed the God Squad, and the various people, the roles are identified, and so these people get together to look at the Tellico Dam. And the Tellico Dam, it turns out, was just a big boondoggle. Okay, anybody know what a boondoggle is? No? Okay, it was basically mostly just to provide jobs and money and so forth to the local area in Tennessee. It was being advanced by Senator Howard Baker, who was, I think, the minority leader of the United States Senate, and very powerful. And it was basically just, another way of looking at it is another term that's used is pork barrel projects. Okay, these are projects that may not be sort of justified on a cost-benefit basis, but because they provide certain economic and political benefits that are favored by whoever in Congress is pushing them, they get adopted, right? So kind of wasteful, inefficient, and so forth. And so the God Squad met and they said, oh my gosh, if we were trying to decide whether this dam should be built, regardless of its impact on the endangered species, this is a wasteful project. It should never be built. Even after we've spent 95% of the money on it, if we just stop now, it would be better off than spending the remaining 5% and continuing to build it, right? So that it was basically they were saying, well, even endangered species aside, this is just a hugely wasteful project. It's just meant to, create this resort development and have all these construction jobs and so forth. So it doesn't stop there. So the God Squad, of course, rejected the exemption. And by the way, as you saw in the reading, only twice has the God Squad actually granted an exemption, and one of them was overturned by the courts. So we've only actually had one real God Squad exemption that has ever allowed the project to go forward despite its impact on the species. But what happens more often is that Congress intervenes. And so in the Tennessee Valley Authority Appropriations Act of 1980, Congress adopts this little provision, and this is what's known as a rider. A rider is a substantive provision that gets attached to an appropriations bill. And why do members of Congress vote for appropriations bills? Money, yes, money to their states, to their districts, right? Who wants to shut down the operations of the TVA or of other kinds of agencies just because you're opposed to the rider? So the rider gets attached to it, and so it rides along with the appropriations, and it basically says the Tellico Dam is exempt from the ESA. Okay, so Congress exempts the Tellico Dam from the ESA. Now, that says something about politics of the ESA. Now, the end of the story is it's not what you would expect. There's actually not a Hollywood ending to this story either way. The snail darter did not go extinct because other populations of the snail darter were discovered in other rivers. Okay, so the Tellico Dam did not cause it to go extinct, and the Tellico Dam did not provide really any of the benefits that it was said to have provided. So the whole thing was a lot of hoopla about something that was actually neither the dam was as important as thought, nor was the darter as threatened as thought. But what we see is the tendency for Congress to step in when the ESA is impeding projects that or development or economic activity that Congress feels is important. One example has to do with the Middle Rio Grande, where Albuquerque gets its water supply, and the 10th Circuit, which is the federal appellate court on which I clerked, said, well, the ESA requires the Bureau of Reclamation, which is managing the water reservoirs. It requires the Bureau of Reclamation to release water into the Middle Rio Grande so that the silvery minnow doesn't die. The minnow needs a certain amount of water, and instead, of course, the water was being taken by the city of Albuquerque for water supply and so forth. Okay, and don't get carried away with this. Okay, it was providing public water supply, but it also wasn't, and there was drought and there was scarcity, but it also wasn't the case that everybody was going thirsty either, right? I mean, there's plenty of, showers and car washing and swimming pool filling and stuff going on as well, right? I mean, so don't get carried away one way or the other on this. I mean, but basically, it's another example where a rider was put in an appropriations bill that exempted the entirety of the Middle Rio Grande from the Endangered Species Act. Okay? Klamath Basin. There's been a lot of conflict over water that is needed to sustain water flows in the Klamath, to sustain salmon in the Klamath River, which is sort of Northern California, Southern Oregon area. And this actually led to an armed confrontation between farmers and federal officials over access to water supplies. So there's a lot of conflict over this, and as you can imagine, the farmers who wanted the water to irrigate their crops were not too happy about the ESA or protecting the salmon. In the end, it's led to a well-known book about just how broken the ESA is, how the politics are so vicious and dirty, and how the conflicts are deep-seated and even violent, and so on and so forth. And that's true, and that certainly was what was happening for a while. In the end, one of the things that happened is the Indian tribes, the government agencies, and the farmers actually ended up sitting down and figuring out maybe not a solution, maybe not an entire solution, but some solution, some improvements to the situation in the Klamath Basin. When I was in practice in San Antonio, Texas, there were two big conflicts over the Endangered Species Act in the area in which I was practicing. One had to do with land development in the Texas Hill Country outside of Austin, in which there were several species that were threatened by any kind of development at all. And so basically, when I was practicing, all development in the area was totally shut down. So you'd have people who had bought, a parcel of land, they wanted to build their retirement home, and so forth. So, it was. You definitely had developers who were, saying, hey, I can't make my zillions of dollars on land development, but you also had grandma who says, I can't build my retirement home on the land where I spent my life savings and so forth. So it led to a tremendous amount of conflict, and then the other one had to do with the fountain darter, which was a couple other species. There's a blind salamander as well, and they lived in these springs that were fed by the Edwards Aquifer. The Edwards Aquifer is this massive aquifer that provides pretty much 99% of the drinking water for the San Antonio region. It also provides irrigation water for ranches and farms, and other sources of water, and it's this big area, and it's also easily contaminated if you have whether it's pesticides or gas station leaks or other sorts of chemical spills in the recharge area over the aquifer. And there's a lot of land development also happening on the outskirts of San Antonio, overlying some of the more sensitive areas of the aquifer recharge. So there's a whole bunch of things going on. At some point, there's a guy by the name of Ron Pusak who had some land that where the aquifer formed, the Edwards Aquifer came up to the surface in a spring that had a high amount of pressure. And so it meant that a lot of pressure was there, which meant that he could drill water wells very easily and with very little cost. And actually he was trying to claim 1/4 of the entire amount in the aquifer. Okay, so this is 1/4 of the aquifer that supplies 99% of San Antonio's drinking water. So, and what he was going to do was he was going to use the water for a catfish farm. So he's going to raise catfish. And what do you know about catfish? Catfish are
dirty creatures. They waste a lot of water.
They're very dirty. Okay, so you take this nice, clean groundwater, aquifer, pristine aquifer water, and you're basically dirtying it up with the catfish. Why is he doing this? Why is he doing this? Not because he loves catfish, not because he wants the water. He wants money. Yes, he wants money. He wants basically to hold the city of San Antonio hostage and have them buy him out for zillions of dollars, right? And that's, I think that appeared in the pleading, zillions, I know. But, yeah, right, but it's a lot of money, right? And I don't remember exactly how much it was, but basically he was basically extorting money from the city of San Antonio. So of course they sued him and so forth. But the bottom line is all of these people got sued by environmental groups for not keeping enough water flowing in the aquifer into the springs to support the endangered species. And the federal court said, the federal agencies have a duty to protect the species. They have a duty to limit all these water users, and because of the no jeopardy rule, and it's absolute. There is a point at which the federal judge, Judge Bunton, federal district judge, declares that because the parties aren't cooperating with his orders, that he is actually going to take over the he's going to take over the entire Edwards Aquifer, and that, as you might imagine, did not fare so well in the Fifth Circuit. They kind of smacked him and said, "No, you don't have that kind of authority," and so forth, and which then ended up leading to maybe some more thoughtful multi-party negotiations about exactly what's going to happen and what's not, and how you can, maintain enough water in the aquifer, but yet also use it and protect it better from pollution. But during this whole time frame, there was enormous political unpopularity of the ESA in Texas. Okay, now Texas, as you know, is very private property rights oriented, a relatively conservative state politically. At the time, this was the early 90s, at the time, Texas had a Democratic governor, Ann Richards, and a Democratic Attorney General, Dan Morales. Okay, these are not conservatives, right? And the politics was a little bit, it wasn't exactly what it is now. It's a little bit more purple than red, okay, just to put it bluntly. And nonetheless, Ann Richards and Dan Morales lead. Oh, and by the way, Ann Richards gave the keynote speech in 1992 at the Democratic National Convention. So very nationally recognized leader. They are calling for the repeal of the Endangered Species Act. Okay, so you've got major Democratic leaders calling for the repeal of the Endangered Species Act. That you need to understand that was the politics that was going on. Now, actually, did Ann Richards or Dan Morales really think this ESA was really going to be repealed, maybe not, but it was politically beneficial to them to say that. So one of the things that happened during this time frame is that Congress enacted a 2-year moratorium on the listing of any new endangered species. Boom, just no listing could occur for 2 years, and then eventually they lifted it. I mean, actually, they could have kept the moratorium on, but they eventually lifted it. But this is where a number of reforms that we're going to talk about here in just a moment came about. But there is some question about, given anxiety about whether we have enough water or not, in the way that the ESA can impact water resources, there is some question about whether the tension between species and water usage, species protection and water usage, is one of the hottest flashpoints in the ESA. But as I was mentioning, we're talking about grandma in her retirement home and some of that kind of stuff. That brings us to restrictions on private, state, and local actions. And this is the take prohibition. Like most environmental law, the statute includes some prohibitions. Then it includes some permits that allow you to do what's prohibited if you meet certain criteria and agree to adopt certain measures. And the sort of the standard thing we're going to hear over and over again is avoid, minimize, mitigate. Okay? Avoid, minimize, mitigate. That's often the requirement to get a permit, is to avoid the adverse impacts first. Secondly is, if you can't avoid them, minimize them. And if you can't avoid or minimize, then mitigate them. Mitigate means offset, do something to offset the impact. So that's a standard sort of three-part aspect of really any permitting system in the federal environmental laws. And with incidental take permits comes what's called habitat conservation planning. Okay, so we're going to talk about that. So Section 9. So we were talking about Section 7 is the no jeopardy rule that applies to all federal agencies. Section 9, it applies to everybody. So actually Section 9 technically applies to federal agencies as well. It's basically no person, so that's private parties, individuals, companies, businesses, whatever, nonprofits, state governments, local governments, basically everybody is prohibited from taking a species, which means to harm. So there's actually a whole long list: harm, harass, kill, etc. So obviously one thing that you can't do is you can't go out there and just shoot an endangered species or poison it or whatever, right? Earlier I talked about annoying the prairie dogs while they're mating, and you looked at me like, really, Professor Arnold? But harass is actually a prohibition in the statute, in the ESA statute. It's one of the things that counts as taking a species. And the idea is that if you bother it enough that it affects its long-term viability. So, for example, the species won't mate, and then it won't reproduce, and it won't survive, right? Then that's an issue. That counts as a take. But for our purposes, a lot of what we will focus on is adverse modification of critical habitat. So adverse modification of critical habitat that harms the species is prohibited under the ESA. And Section 10A of the Act is the provision that allows takings under certain circumstances if you obtain an incidental take permit from U.S. Fish and Wildlife Service or the National Marine and Fisheries Service, we talked about certain species there, right, the certain fish species. And in order to get an incidental take permit, you have to prepare an HCP, Habitat Conservation Plan, and then this is the avoid, minimize, and mitigate scenario. We'll talk about Commerce Clause and takings issues later in the semester. Later in the section.
So under the ESA with take including collect, does that apply even like for beneficial, like if you're, some endangered species injured somewhere and some volunteer organization takes?
Yep, you have to actually get a permit. Now there are some nationwide permits for emergency rescue, and you have to follow a whole set of procedures when you do it, right? I mean, so it's very tightly regulated. But yes, if you are a species recovery person, and there's going to be a permit that covers your action. And when we talk about a nationwide permit, we talk about sort of like a general permit that says if you do the following things, and you usually have to notify the agency. So here's this endangered owl, and it's lying on the ground like this. So you usually, and there's some rules about how maybe you can take certain actions, preventive actions right away, but then notify the agency, that kind of thing. But that's how it works. But part of the idea there is we also want to prohibit the trade in endangered species. So we want people going out collecting. And so it is not a good thing to go pick up feathers of endangered birds off the ground and keep them, because you could end up being criminally prosecuted. Okay? So the take prohibition applies to fish and wildlife species. Plant species get lesser protection. You cannot harm or remove endangered plants on federal land. But if you have an endangered plant on your own land and you plow it over, you mow it over, whatever, that's not kept covered. It's fish and wildlife species. Any person, we talked about that, blah, blah, blah. Any take of the species, and we're talking about import, export, trade, possession, etc. as well. Okay? And so here's as I was telling you, harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, collect, or even to attempt to engage in such activities. And significant habitat modification or degradation that actually kills or injures the wildlife by significantly impairing essential behavioral patterns, including breeding, feeding, or sheltering. Okay? So, and one of the challenges here is that even if you didn't know the species was endangered, you may be in violation of the statute. I mean, you could actually be prosecuted. Okay, so in other words, you don't have to know that what you were doing was a crime. Okay, yeah, I mean, as long as you knew what you were doing. So, like for example, if you step out of your car and there's something that's there on right beside your car, and you step on, right, that was an accident, right? You didn't intend to step on the species, right? That's not covered. But if you intended to shoot an arrow at the bird that you thought was, just a regular old abundant bird, and it turns out it's an endangered bird, you intended to shoot the arrow at it, you are liable even if you didn't know it was endangered. Okay? So the act itself refers to endangered species and wildlife. The act expressly allows the agency to extend those protections to threatened species, and they have for the most part. Okay, so the agencies have extended the take prohibition to most threatened species via regulation. That's actually one of the things that's under review for potential change in the Trump administration. Notice it's any person and also individual members of species. this is harm, blah, blah, blah. So this is incidental, this is section 10A, allowing incidental take. And here's the scientific stuff up here where you can allow the scientist to, try to save the species by, engaging in recovery activities and so forth. And just go up. Okay, 10A2 requires the submission of a conservation plan that specifies the impact that will likely result from such taking, what steps the applicant will take to minimize and mitigate such impacts, and the funding that will be available to implement such steps, alternatives considered, and such other measures that the Secretary may require as being necessary or appropriate. And these are the findings that have to be made, okay? So notice what is going on here with the granting of a permit. What's the process? Statute expressly calls for what process? There. Notice and comment. Okay, you should. That's one of those phrases that you should be embracing in this class. Notice and comment. Okay. So notice what's going on here. So not only would we have the regulations that the U.S. Fish and Wildlife Service has adopted, being adopted pursuant to notice and comment, but also the granting of incidental take permits are done pursuant to notice and comment, right? The opportunity for the public to comment on the proposed permit. And so in granting or denying in granting the permit, the Secretary has to find that the taking will be incidental. Applicant will, to the maximum extent practicable, minimize and mitigate the impacts of such taking. Applicant will ensure that the adequate funding for the plan will be provided, and the taking will not appreciably reduce the likelihood of survival and recovery of the species in the wild and any other measures required. Okay? So, what does that mean? What does that mean? If you are a U.S. Fish and Wildlife Service official, and you are dealing with applications for incidental take permits, what are you going to need to do? Just practically.
All they have to do is
Grade me.
Okay, and the correct answer is not sit in your office and stare at it and freak out. Okay, just what are some things that you're going to have to do as a federal official trying to address applications for incidental take permits for endangered species?
You'll have to go out into the field and
Okay.
at least take a look.
Okay, go out in the field and take a look. Why?
Well, you need to make sure that that the maximum extent practicable is something that's something that you can obviously detect, or maybe you have to dig further. You just have to orient yourself and not stay in the office.
Okay, so will going out in the field tell you whether the applicant is going to minimize and mitigate the impacts of the taking to the maximum extent practicable? Is there a possibility that you could find that information without leaving the office? How's it going to work?
Maybe just your own research?
Okay, so this could be research, right? What kind of research? Okay.
Can you talk to experts on, consult them about the plan to minimize?
Okay, what kind of experts?
Scientists and environmental.
Scientist? Well, okay, what kind of scientist? Environmental, okay, maybe ecologists. Yeah.
I think one thing you need to know is basically the population that's left, and so ensure that this taking's not gonna, if there's only 10 of whatever endangered species left, that you're not taking out,
Right.
a large percentage of the population.
Because you're going to have to know something about the population. You have to know something about what the applicant is going to do, right? Okay, how are you going to know what the applicant's going to do?
The application should state it.
Yes. Okay, it's really this practical. The application will tell you what they're going to do, right? Right, exactly, yes? Okay, there's an applicant out there. They are applying for this, right? So there's going to be a process, and there's going to be certain information that they have to provide, okay? Now, is it possible that you might have to do further factual investigation about their plans, right? Follow up with certain questions. Get in touch with their engineers, their planners, their hydrologists, their so on and so forth. These very right? Does everybody see? Yeah, and to make sure that you know precisely, clearly, exactly what they're going to do so that you can assess the kind of impacts. Okay, then in order to assess the impacts, you're going to have to know something about the species, the population or populations, their what? So the species, their populations, their habitat. Yes, habitat, right? So, right? I mean, what are they? Are they little cave bugs that live in a cave? Are they birds? I mean, if they're birds, where do they roost? Where do they, where do they lay their eggs? Where do they mate? Where do they eat? Right? Does everybody see? Okay, so getting into thinking about all this. So you're going to need to know something about the habitat, but what's going to be absolutely critically important is you as a lawyer are not going to be the source of information about what kind of impact activity X is going to have on species Y and its habitat, right? So who's going to do that? It's going to be scientists, probably conservation biologists or fish and wildlife biologists or other kinds of scientific experts, possibly ecologists, right? Especially if it's more systemic. But you're going to need the right kind of experts, and they're going to have to do what? What are they going to have to do? Like sit around and guess? No, they're going to have to do research, study, right? There's going to have to be some sort of study, some sort of assessment, etc. Now, there might be a whole bunch of studies that have already been done, and they can take that information and just do analysis based on existing studies, but they're going to have to, right? And so all that is creating what? From a legal standpoint, it's creating what for you?
Profile?
No. Standards are there.
The plan? A case?
Not decedents' estates, not business organizations is creating for you. Evidence, yes, evidence, right? Okay, right? Do you remember when we were doing all the sort of administrative process? You have to consider all of the relevant factors, right? The standards that are there, right? So what does that mean for that part of it for you? It means you or whoever's making the decision better make sure you go through each and every one of these and address it thoroughly, right? If you skip over one, what's going to happen? There should be a lawsuit under the APA, and you will have abused your discretion by having failed to consider one of the relevant factors, right? So think about it. Again, you want to make sure you're hitting all the boxes, okay? And you are going to have evidence to support your decision. How much evidence? Beyond a reasonable doubt. No. basic administrative law. It's how much evidence? Nope, it's not preponderance.
Arbitrary.
Nope. That's the standard review. Substantial evidence. Substantial evidence. What is substantial evidence? Okay, now we're back to the law. So we went off into science for a little bit. Now we're back in the law. Substantial evidence is such relevant evidence as a reasonable person would accept in making a reasonable decision. Right? Everybody follow? So you see the kinds of things that you need to think about. So you need to make sure that good science is being done, is being correct, but you aren't the scientist. Right? You yourself aren't the scientist. So you're not going to go out there and do the studies yourself. Okay? But as the lawyer, you are making sure that all the process, notice and comment, is being followed. All the standards are being applied, right? Making your way through and considering each and every factor that the statute requires you to consider, and making sure that there is good evidence to support the decision that's being made, right? See what I say? Substantial evidence behind it. Okay? And so that's what you're doing. Okay? That it takes us a little while to get there, but that is the standard approach in almost all administrative decision making. Okay? This is across the board, and this is not just environmental law. So dealing with things like species and habitat is environmental law, but that basic sort of how the administrative process works is going to be true with almost every administrative agency that you deal with. Okay? It's just sort of basic administrative law. But this tells you what that you need to look at. Now, having said that, let me tell you that during the second Bush administration, actually the first Bush administration was relatively strong on the ESA, but during the second Bush administration, there was a assistant director of the U.S. Fish and Wildlife Service who was a lawyer. Her name, I think, was Julie McDonald, if I remember correctly. I may have that name wrong, and so I hope I haven't, slandered or libeled or somebody. But anyway, but I think that was her name. And she basically would take the decisions, or the analyses and so forth written by the administrative staff, the experts, and rewrite them. And there was a point at which there were lawsuits over this, and this pattern became known. It became, of course, actually it's not too hard to discover it, to find out what her role was and what she did with a lot of these things. And you can be sure that environmental groups were well aware of this and brought this to the court's attention, and the courts came down on the Fish and Wildlife Service hard, because they're like, okay, she's not a scientist, okay? That's not her role. She's a lawyer, right? And so she can't just go be changing the scientific analysis. Okay, that is an abuse of discretion. And in the end, I forget how many dozen of different agency decisions had to be withdrawn and redone because of her improper influence she was a political appointee. So that was another thing, sort of the role of politics as opposed to following the statute and applying the evidence. Okay, so that's what it goes on with the incidental take permit process. Okay, so one of the issues is whether the was a lawsuit over the idea that adverse modification of habitat constituted a take of the species. So is that a legitimate interpretation of the statute, or is that too broad? So this had to do with another sort of flashpoint of the ESA having to do with logging, timber activities in forest in the United States, including the red-cockaded woodpecker and the northern spotted owl. Okay, and this was very controversial. A lot of people who worked in the timber industry were very unhappy with the ESA and blamed it for the decline of the timber industry and the loss of jobs and so forth. So there was a case called Sweet Home Chapter of Communities for a Greater Oregon versus Babbitt. What a great name, and so forth. And so poor Alabama, they no longer had the monopoly on Sweet Home. So the U.S. Supreme Court heard this case in 1995 and determined that indeed adverse modification of the critical habitats for species would indeed be considered a take, would be considered harm to the species so long as it actually killed or injured the species by reducing its likelihood of survival. Okay, so all you have to do is reduce the likelihood of survival. Okay, but one of the things that happened in the case, though, was that the Supreme Court then drew some parameters. So Justice O'Connor wrote an opinion in the case in which she said, okay, but principles of proximate causation have to be followed here. Okay, so basically she's imposing some legal principles that you learn all the way back in tort law onto the ESA and say, hey, at some point, if an action is too remote from the actual impact of that action, it's no longer considered subject to the ESA. It's no longer prohibited by the ESA. But there has to be some degree of proximate causation there. So we talked about the incidental take permit process. In that process, habitat conservation plans are required. We talked about what needs to go into habitat conservation plans. The kind of habitat conservation plan can be very project specific, or there can be broader regional habitat conservation planning or multi-project habitat conservation planning. As you might suspect, the broader the plan, the more different kinds of activities and landowners and circumstances it applies to, the better it is. The better you can actually conserve the habitat than if it's just very project specific. So think about this for a moment. So let's assume for a moment that you have one parcel of land and you've got some trees here and some trees over here, okay? And let's say this is the road, and there's going to be development over here, right? That's going to, by the road, that's going to cause, that's going to require you to remove trees and so forth. So, you're going to then protect, your plan is about protecting these trees, and maybe even you might add some trees, right? Add some trees over here, near there to kind of build that up. Okay, right? Okay, that makes sense? But this is really what's known as a habitat fragment. It's just a fragment, it's just a little piece, okay? And if you're a bird, and you're like in those trees, where do you go, right? You used to be able to fly over to these trees, right? Now you're like on a little island there, right? Does everybody see that? That is not great habitat conservation planning. It would be so much better if all of these parcels in this area could have a big conservation plan that says, hey, maybe we've got a whole big forest here, and maybe it's even like a little corridor that goes along out here, right? And so and species like corridors, by the way. We like to be able to move along corridors and so forth. Think about that. Think about how they're going to be hiding out from various predators and so forth in those trees, right? As opposed to flying out here to try to get somewhere else, right? So they like the corridors and so forth. And so, hey, maybe we could protect all this, and maybe these landowners could buy out that landowner. But do you see, I mean, this is real simple, but this is sort of a basic sort of illustration of why broader conservation planning across more land, across more habitat is generally better. You get better conservation outcomes. But the problem is that legal title to the land, who owns the land, who controls the land, is all very fragmented. And very often, various kinds of regulatory controls are also fragmented. So you might have the city, you might have the county, you might have, right? So just think about preserving the Indiana bat in this area. We've got Indiana, we've got Kentucky, we've got different counties, we've got different cities, etc. Trying to get all those to cooperate is much more difficult.
And both this and the last one that we talked about, the minimization and mitigation, is this a collaborative thing, or does the agency, or does like the Fish and Wildlife Service act kind of like the Godfather, where they just say, no, this plan isn't good enough, or do they sit with the people that submitted the application and say, have you thought about this, can you do that?
So it depends in part on which official is working with which applicant, okay? So some applicants are more solicitous of the agency's guidance and expertise, and others are, here's my application, you know, approve it, damn you, right? I mean, that's kind of the gist, right? And likewise on the officials, okay, some of them have good interpersonal skills and the ability to cooperate, and others are like, I'm the expert, I'm in charge, I'm gonna tell you what to do, okay? So again, I'll give you another little story, but when I was in practice in San Antonio, part of the unhappiness was that landowners were unhappy about this, and the phenomenon that you read in the book of shoot, shovel, and shut up, right? You saw that in the book, okay? That was the 3 S's, shoot, shovel, and shut up. Okay, that was definitely happening, and you can imagine older, long-time ranchers in the Texas Hill Country were like, you know, what the heck is the Endangered Species Act, and who are these people to come tell me what to do with my property, right? Those, you know, and so of course it would be so much easier if they just removed any species before anybody found it on their property. Okay? So the U.S. Fish and Wildlife Service did what? They hired a law enforcement person who I swear was John Wayne. So I mean, this guy looked like him, he talked like him, and he basically, part of his job was going around telling everybody how strictly the U.S. Fish and Wildlife Service was going to enforce the ESA. And when I went back to the firm after having gone to a breakfast meeting of the environmental law section of the San Antonio Bar, and I said, you know, what did you, what was it? What was the gist of the presentation? I said, you know, this guy looked like John Wayne. He basically said, if you even look at an endangered species the wrong way, I'll shoot you. Right? It was very, you know, Wild West law enforcement. Okay, well, you know, I mean, okay, so Texans, to some degree, appreciate that kind of law enforcement. They love the Texas Rangers, right? Okay, right? But when it has to do with, when it's the U.S. Fish and Wildlife Service telling them what they can do with their land, they really don't like it, right? They really chafe at that. So that led to an enormous amount of conflict. So, I'm sorry. So if, generally there should be collaboration, but sometimes there is, sometimes there isn't. It has gotten...
They were also just so busy that it's just like easier to just stand denied and be done with it and pass the paper along.
Yeah, except that there'll be a lawsuit over it and so on and so forth. And so, but yes. Well, the other thing that's happened is in more recent years, most of the people who work for agencies like the U.S. Fish and Wildlife Service have gotten their education in programs, sometimes undergrad programs, but many of them, like master's programs and so forth, where they learn collaboration skills, multi-party negotiation skills, communication skills, that kind of thing. So it's more, that's more the case. By the way, I'm going to go ahead and mention it now because it's fresh, but it also works the other way, too. And this really relates to problem number 2, but I want to just point out while I'm trying to sort of illustrate this idea about how training of experts in a field changes over time. If you look at the practices of most younger farmers these days, they are much more practices of sustainable agriculture because they've all gone to college and they've learned sustainable agricultural practices in the way that older farmers often didn't, right? And so there's been sort of more of a shift in how that's done. And so, but what the example here is the agency officials have developed more skills of cooperating with the regulated parties. All right, so this basically is just a re-summary, and just to point out, there are going to be terms and conditions imposed on the permit, includes reporting, and I mentioned adequate funding, but that is key, right? The adequate funding. So regional habitat conservation plans are this is sort of what I was talking about. So that's actually what ended up being the solution in the area around Austin, okay? Because, really, who has the time and money if you're like an individual rancher, you're an individual grandma who wants to build your retirement home and so forth, to go through the process of dealing with the U.S. Fish and Wildlife Service. So really what happened is, for those people who were patient, eventually the local government agencies worked out a regional habitat conservation plan with the federal agencies, and basically you could get your development permit if you followed certain development practices, and you basically paid a bunch of money into the Habitat Conservation Fund. Okay, so basically, Grandma could then build her house, but she had to pay into the Habitat Conservation Fund, which basically was protecting habitat on other lands that had been set aside. Okay, that had been set aside. We talked the other day about candidate conservation agreements, candidate conservation agreements with assurances. These are all agreements where certain conservation measures are going to be taken with respect to either listed species, that's the conservation agreement, or candidate species that might be listed, okay? And the most commonly used one, or the one that's most popular, is candidate conservation agreements with assurances, CCAAs. And CCAAs, I know it's not up there, but it's on earlier, on a slide earlier when we talked about it. Okay, CCAAs mean that if you provide these conservation measures that you've agreed to, and they end up being negotiated, right? But you provide these conservation measures, we won't ask more of you later. That is also sort of the underlying gist of what was called the no surprises policy. So I told you about the moratorium on listing of new species. Well, one of the things that the Clinton administration had to do in order to get Congress to lift the moratorium was adopt something called the no surprises policy, which is, again, if we regulate your land and you get an incidental take permit and we tell you if you do A, B, and C, everything will be okie dokie, okay, right? Obviously not a little more sophisticated sounding than that, but that's the gist of it, right? okay, then we promise there will be no new things required. There will be no surprises down the road. We're not going to come in and say, oh, lo and behold, now there are new things you have to do. Part of the problem with no surprises policy, though, was that there were a variety of exceptions. Like if an entirely new species was found on your, different endangered species was found on your property. If there were certain things that weren't known to the agency, but you should have known, then it might not apply and so forth. Citizen suits are big under the ESA. Okay, the ESA has a citizen suit provision, so that means environmental groups sue the agency, and they sue private parties that they believe are violating the ESA, but primarily they sue the agency, and so that includes all those issues that we talked about before: standing, ripeness, exhaustion of administrative remedies. You have to go through all that when you're doing those suits. But the other thing, I talked about this earlier, Bennett versus Spear being the example. Some of the citizen suits under the ESA are by regulated parties, by developers, property owners, businesses, industry that are unhappy about the regulation, believe that it is too expansive, that it goes beyond what the ESA requires. So we've got that as well. And then we talked about conservation biology and so forth. One of the things that we've emphasized here with the ESA is that the habitat of the species is part of broader ecosystems. We kind of glossed over the early sort of purposes and language in the ESA that Congress adopted. And one of the things that's there is it talks about protecting ecosystems. But from a legal analysis, that's just a bunch of BS. Okay, it's just a bunch of BS because the Act on its face, when you actually apply Section 7 and Section 9, it protects individual critters, right? Individual members of federally listed endangered and threatened species. And now, it also protects their habitat, but that is not the same thing as an ecosystem protection system or ecosystem management system. Why? Ecosystems are much broader, okay? Much broader than a population of species, much broader than just the habitat. There are all kinds of functions in ecosystems that might be related to the species, but might not be implicated by or regulated by the ESA. So, for example, watersheds. Okay, so watersheds are areas of land that drain to a common point on a body of water. And watersheds, one of their functions has to do with flood management. So floodplains serve important flood management functions. Okay, so you do some developing in the floodplains. Okay. Well, if the land on which you are developing happens to be home to some sort of endangered or threatened species, some sort of toad or something like that, okay, now all of a sudden the ESA applies. But if the toad doesn't live there, right? If the land where you're developing, or the toad's not endangered, okay, so it's just a common toad, plenty of them around, okay, your land development is going to affect the capacity of the floodplain to moderate and mitigate floodwaters in the watershed, which is ultimately going to affect the functioning of the watershed as a whole, including how those species that live in that watershed function, you know, their vitality and health, and they're going to have to adapt and so on and so forth, right? But it's too remote, right? You're not really modifying the critical habitat of the species. Does everybody see that? Okay, so it's not really an ecosystem protection function. Why is that relevant? Why would we care about that? Okay, our problem that we're working on has two parts to it. It's two parts to it. What's our problem? There are two major environmental resources that we're concerned about. And one is grasslands, and the other is prairie dogs, okay? And which one of them is protected under the ESA? The prairie dogs, okay? They may or may not be, but right? But prairie dogs is the relevant unit of analysis for the ESA. The grasslands are incidental. The grasslands are protected only for those particular parts of the grasslands where we know that endangered species live, and if we modify or use the grasslands in a particular way, that will harm those endangered or threatened species. Okay? So in other words, what I want to point out to you here is the ESA is not a great tool for if you were saying, hey, I'm really interested in a grassland protection program. It's a more appropriate tool if you're interested in a prairie dog protection program. Okay, and then I talked about this before, the substantial evidence test and so forth, interpretation and so forth. So, all right. So we don't have a lot of time, but now we're going to turn to the next big statute, which is the National Environmental Policy Act. And I know you're like, Professor Arnold, my brain hurts, so I've already learned enough. But we got to keep moving. We got to work on this. So the National Environmental Policy Act is another of these big, broad, sweeping federal statutes that was enacted early on, like the ESA, and like the ESA, has less complicated technical rules, but actually has quite a bit of influence over what happens. So the whole point of the National Environmental Policy Act, or NEPA, as it's called, NEPA, is for agencies to consider the environmental impacts of their actions, to take a hard look at what kinds of environmental impacts their actions will take before they take the actions. And the agencies have to disclose publicly the details of their proposed projects and actions and their likely environmental impacts. So it's sort of a sunshine kind of law, right? It's Justice Brandeis talking about sunshine being the best disinfectant. Well, the fact that these details have to be made public has effects. NEPA also had quite a bit of litigation, which can cause delay, can be a rallying point for opposition to certain federal projects and actions, can increase the amount of scrutiny and accountability, and can be a mechanism for seeking and obtaining information. Okay? But the general, and by the way, one of the things I just want to go ahead and say now, it's going to come up later, but one of the outcomes of NEPA is we actually now know a whole lot more about environmental impacts of all kinds of things. We know how to assess that, right? So in other words, say for example, the impacts of highway development on wetlands. When we first started doing this, we didn't know exactly what kinds of impacts there would be. Now, there are sort of standard formulas. Like you don't really have to know that much to actually just take that information and plug it into a formula that now everybody knows because that knowledge developed in response to compliance with NEPA. Okay, so it actually generates the advancement of scientific knowledge because it's responsive to a legal requirement. But the general theme here is that NEPA involves procedural duties, not substantive mandates or restrictions. There is nothing in NEPA that prohibits an agency from taking an action that has extreme, horrible, outrageous environmental impacts. Okay? So I mean, as long as the agency has done the analysis, made the information public, considered those extreme, outrageous, horrible impacts, and says, hey, despite these impacts, this project is so important, we're going to do it anyway. NEPA doesn't prohibit that at all. Okay? So it is a set of procedures that have to be followed, but not substance. That is different than the environmental impact laws in California and New York. California and New York have state environmental impact laws that are strong, and they require not only information and assessment and consideration, but also they require the agency to minimize and mitigate the environmental impacts. Okay? Here, under NEPA, we're going to discover that the agency has to consider minimization and mitigation measures, but it doesn't actually have to adopt them. So when an agency's action is challenged under NEPA, there are three types of challenges. One is where the agency failed to prepare an environmental impact statement. The agency does not prepare an environmental impact statement. Most of the time, you can anticipate a lawsuit. Now, obviously, there's lots of little things that nobody's going to sue over, and no court would ever require the agency to prepare EIS. We'll get into that. But if it's a major action, it's controversial, the agency has not prepared an EIS, then there's going to be a lawsuit. If the agency does prepare an EIS, the lawsuit instead may be over the adequacy of the EIS. Does the EIS meet the standards required under the statute? The third type of lawsuit is failure to follow the required procedures. Failure to follow the required procedures. Now, some of those might have to do with days and times and how much, but most of it has to do with, did you make the information public, and so forth. Did you do the process at the right time, and so forth. All right, so let me introduce this basic concept here, which is that when we talk about the requirement to prepare an EIS, and the agency hasn't done so, we are asking, first of all, is the agency engaged in a major federal action? And what's the scope of that action? It deals with issues like tiering and cumulative and synergistic impacts and supplemental information, that kind of stuff. Okay, we'll get into those. Secondly, are there significant impacts on the human environment? And third, what's the scope of those impacts? So these are the three big questions that get addressed in any sort of challenge to the agency's failure to prepare an EIS, or alternatively, they go into the agency's analysis about whether they do have to prepare an EIS. Is there major federal action? Are there significant impacts on the human environment? And what are the scope of those impacts? So we will then pick up the beginning of next class. But keep going, don't stop with the reading and so forth, because we will, by the end of next class, start in on the federal lands management, and I told you we'll eventually catch up here. So.